Okay, class, today I'm going to record your lits, and it's 160 lits. Number 160 lit, you have Officer Kirk, Main Boulevard, West Main Boulevard, Dodge, Mr. Cerf, Mr. Nash, and Mr. Rich. And it's a long answer, and the question is, what did you observe while on patrol? This is your 160 lit final, number 1, for 5 minutes. Myself and Officer Kirk were traveling westbound on Main Boulevard in approximately the 1400 block. We noticed several parties near a garage by the trailer house at 1401 West Main Boulevard unloading some saddles. They were unloading the saddles out of a gray Dodge pickup truck. Upon seeing them, someone in the group saw us about the same time and yelled and pointed towards us. Then we saw a scurry of movement and several people running from the area at that time. I turned the car around on Main Boulevard and pulled them into the driveway. At that time, there was one party standing by the pickup, a second party inside the garage, which the door on the garage was opened, and a third party that we had seen run from the area was around to the west side of the garage, hung up on a wooden fence. The party that was hung up on the fence was a Mr. Turp. One of the parties that was standing by the truck was Mr. Nash. The second party was in the area of the truck. One was behind the truck and was in the garage and was later identified as Mr. Rich. We approached and I asked them for their identification. A short time after, we got our vehicle stopped for an official contact. After stopping the patrol car and getting out, I did contact Mr. Cerf, who was hung on this wooden fence. He was wearing a ski-type shirt. He tried to scale the fence and got hung up. He'd lost his grip, but material caught and twisted, so he was hanging loose. I managed to release him, and I brought him around to the police car where Officer Kirk was with Mr. Rich and Mr. Nash. At that time, we noticed that there were several items in the back of the pickup. There were a couple of televisions and some other electrical appliance type items. Now, at that time, being aware of several incidences in the past in this area, we felt it wise to investigate these parties because we suspected something on the order of a theft had occurred. We advised the parties of their constitutional rights according to their Miranda warning verbally, and Mr. Rich and Mr. Cerf related that they did not want to talk to us. Mr. Nash related that he would talk to us. I advised Mr. Nash that he had the right to remain silent and that anything he said could be used against him and would be used against him in a court of law, and that he had the right to have an attorney present before any questioning if he wished one. If you cannot afford to hire an attorney, one would be appointed to represent him. If he wished, he might be represented by the public defender's office. I asked him if he understood these rights, and he indicated that he did. Then I asked him, having these rights in mind, if he wished to talk to me, and at that time he indicated that he did. At that time, Mr. Nash pointed to the back of the pickup at a pile of items just inside the garage, which consisted of the saddles that we had originally seen when we were driving down Main Boulevard, several Indian blankets, and a couple of wild game heads that were mounted. And he indicated to me that the items had been stolen by himself and the other two parties that evening. At that point in time, we stopped Mr. Nash from making any further statements to us. The parties again were advised of their rights. All three parties, including Mr. Nash, indicated that they did not wish to make any further comments. At that point, we had the police dispatch an assistant district attorney to the scene, and through coordinated efforts, we finally confiscated the pickup truck, the items that were in the back of the truck, and the items that Mr. Nash had pointed to in the garage. We put those items back in the back of the pickup truck, and we took the truck to the police station and secured it in the basement of the police station. Upon securing the truck in the basement of the police station, I was advised by the jailer on duty who was working that night that Mr. Nash wanted to speak to us again. At that time, myself and Officer Kirk got Mr. Nash out of the holding cell and took him up to the complaint desk in the police station and re-advised him of his constitutional rights on the standard written form. At that time, Mr. Nash related that he did want to speak to us. He told us that, and then you have your second 160 lit. Proper names, you have Mark Hill, Legal Aid Society. You have Attorney Frank Young and Attorney Young and Mr. Young. Okay, this is going to be then 160 lit number 2 for 5 minutes for your final exam, okay? On August 7, the police arrested the defendant, Mark Hill. He was one of 4 men who were allegedly involved in an armed robbery and homicide at a store. The crimes were committed on that date at 10 p.m. About 1:20 a.m. the next day, the police requested a group of witnesses to the crimes to view 2 lineups. These lineups included Mark Hill and 2 other men who the police thought were involved. Prior to the lineups, the police called the Legal Aid Society and asked that a lawyer be present to represent the suspects. In response to this request, Attorney Frank Young went to the police station and he spoke to each one separately. He told them that for the time being he would represent them, and he briefly advised them not to make a statement to the police without a lawyer being present. However, there was no talk about the lineup. After the lawyers spoke with the suspects, the police held what they called a practice lineup. The witnesses to the crimes were not present. This practice lineup consisted of Mark Hill, 2 other suspects in the crimes, and 4 men who at that time were inmates of the county jail. These 7 men were dressed in slacks without coats or ties. After the practice lineup, Attorney Young objected to the ratio of suspects to non-suspects. He also objected to the type of clothing worn by the men and to the differences in their height. He received no assurance that the police would make any changes to the lineup. At that point, he said that he would not participate in the lineup, and he left the police station despite being asked to stay. After he left, the defendant requested that he be allowed to consult with Mr. Young. The police did not tell him that he had left, and they made no attempt to get another lawyer for him. The second lineup was then held, and it was similar to the one held for the benefit of Attorney Young. The participants did not wear coats or ties. No lawyer was there to represent Mark Hill. At the lineup, 2 of the 17 witnesses identified him. After this lineup, 1 or more of the witnesses asked to see the lineup with the men wearing suit coats. To comply with this request, the police told 2 of the suspects to put on their own jackets and ties. The other men in the lineup were provided with suit coats that belonged to the detectives. Prior to the third lineup, the defendant learned that Attorney Young was not present, and he asked to be represented by a lawyer, but the police made no attempt to get one for him. At this lineup, 2 more witnesses picked out Mark Hill. At a motion hearing, the defendant asked the trial judge to suppress the identification made at the second and third lineups. The judge granted the motion with respect to the third lineup because counsel was not there and because the lineup was too suggestive. As to the second lineup, the judge ruled that the state could use the identification at the trial. The judge held that counsel was present and that the lineup was not suggestive. The state has appealed the trial court's order which suppressed the third lineup, and the defendant has appealed the trial court's order which allowed the state to use the second lineup at trial. Although Attorney Young was neither retained by Mark Hill nor appointed by a court, his presence at the police station was in accord with a contract between the county and the legal service agency. We have held in the past that the presence of a lawyer at the lineup was all that was required, regardless of whether or not the lawyer represented the suspect at the trial. The real question is whether or not the trial court was correct when it said that the presence of counsel at the practice lineup carried forward and gave Mark Hill representation at the second lineup. We think it did not. The purpose of having a lawyer present at the lineup is to allow him or her to observe the procedure and to describe it in court at a later time. Counsel was not there when the police constructed the second and third lineups. The trial court held that the third lineup was barred because of the absence of an attorney for the defendant. This was equally true of the second lineup. The fact that Attorney Young was present during the practice lineup and made some suggestions does not support the finding that he was, in effect, present at the second lineup. He was not present to observe and thus could not testify. Okay, and those are your lit tests, you all. Good luck. Type them up. Abide by the timelines, and I will send you all emails tomorrow. We have Q&A multi as far as registration. Okay, have a good day, you all. Type them up, see how you did.